Okay. Mr. Miller, on behalf of, Ms. Hampton.
Judge, if I may, Ms. Hampton does not believe that an order is necessary. That this is one of the biggest cases the country has had, and that transparency is very important. Since I've been working with her for the last 2 years, she has always said that she wanted to be 100% transparent. And that is why we are opposed to having any kind of regulations on what we can expose and what we can't. But with that in mind, we will adhere to any court order that the court does, and we'll do so with diligence. But Judge, in being transparent with the court and to make sure that nobody else gets blamed for what happened, and so that I can go to sleep well tonight, Judge, I did release those videos to one outlet, and on all candor to the court, I need the court to know that.
Well, I appreciate that candor, Mr. Miller. Is there anything else, though, you'd want to add in terms of, I suppose I would lodge it as an objection to the protective order, but not a vigorous one, I suppose. Is there anything else you'd want to add, though, your thinking behind why you felt these proffers needed to be part of the public record? Because it feels like that should be part of the analysis that I have to do of justifying a protective order.
Okay, if the court will entertain me, Judge, all 4 of those people that did their proffers, they stood in front of you, they did their plea, it was all recorded, it was sent out there for the world to see. And to put those proffers, hide those proffers that show all the underlying things that went into those pleas, it misleads the public about what's going on. I don't believe that 2 of those defendants were directly related to my client. And I don't believe that either one of those hurt my client. If anything, I believe they helped my client. And the public needs to know that. So please keep that in consideration in any order that you do.
And Mr. Miller, how would your ability to eventually get that in front of the public at a trial be foreclosed by a protective order saying this shouldn't come out until it's determined to be admissible and it should come out at the trial?
Judge, the problem with that is that this is a very, very public trial. We all know that. How many newspaper organizations are out there right now looking at it? That allows the DA's office to set the tone for the entire trial without giving consideration to the other side of the coin. And that's what needs protecting, Judge. And the public has a right to know.
Well, it's a good slogan, but do we have any case law that says pretrial discovery is a part of our First Amendment concerns? I know Mr. Clyde is sitting there just waiting to be teed up here on behalf of the media organizations. But it seems like having open files for everyone to start litigating the case before we actually get inside of a courtroom comes with a lot of side effects. I don't know if we've thought through.
Judge, I cannot argue with that logic. But so far as case law on these issues, I can quote you a couple of things, but note that the state's only case law that they came up with was a case that wasn't even related to Georgia from 1993. There's just not a lot of Georgia law on this particular issue.
No, I certainly grant you that. I think we're a bit unmoored here in Georgia on this issue, but I'll put all those thoughts in the order, which I will hope to get out by tomorrow morning. All right, Mr. Miller, if there's anything else you want to add, if not, I will move it on to Mr. Greenberg. Anything else, Mr. Miller?
No, Your Honor. I appreciate your time.